Welcome to the Madrid Protocol and Opposition and Section 45 Proceedings webinar. My name is Natalie DePaulson. I am a member of the Opposition Board and will be giving the webinar today. Also with me is my colleague Jennifer Galliano, who will moderate any questions as they come in. So you are more than welcome to type in questions, and I anticipate that we will have time to answer at least a few questions today. With respect to the questions posed, for questions on the Madrid Protocol and Opposition and Section 45 Proceedings, we will be grouping similar questions together and providing more information on these questions in coming months, either through directly answering posed groups of questions and sending out a message either to attendees of the webinar or to a listserv message generally. Elsewise, we'll ensure that the questions are answered in the resources that the Trademarks Opposition Board are preparing for the coming into force. For questions not related to the webinar or the topics of Madrid Protocol and Opposition and Section 45 Proceedings specifically, we will be forwarding these to the appropriate groups at CIPO so that they are aware of these questions and will include the answers in the resources that they are preparing. Now for the official introduction. This webinar will provide an overview of the impact on the Madrid Protocol on opposition and Section 45 proceedings against what we've termed protocol applications and protocol registrations by going through the Trademarks Regulations. We'll start today with a brief review of the Madrid Protocol, and then we'll go through each of the regulations concerning opposition against protocol applications and Section 45 proceedings against protocol registrations. To situate this in terms of CIPO's work towards coming into force, we have received the comments on the publication of the Trademarks Regulations in the Gazette, and these are being considered. The Opposition Board has also drafted a practice notice which will provide further details on the proposed procedures governing opposition proceedings and Section 45 proceedings with respect to protocol applications and registrations. This practice notice will shortly be reviewed by stakeholders nominated from the 3 main IP associations in Canada, and after that will be released for comment. I mention this because at some points today I may mention that further detail about particular topics will be provided in the practice notice. So to file an international application and enter the Madrid system, a trademark owner must have a trademark application or registration on which to base it on. This is called the basic mark. Once there's a basic mark, an international application can be prepared, and this would include the trademark, the basis of the entitlement to file, the representative information, the goods and services, and the countries in which the protection is sought. The Trademarks Office of Origin, for example, the country that the applicant is domiciled in or that they have a real and effective commercial establishment in, certifies that the international application is the same as the basic mark, the trademarks are the same, and in the case of the goods and services are not broader than that within the basic mark. The Office of Origin certifies the international application and forwards it to the International Bureau. The International Bureau examines the international application for formalities, including the designated contracting parties, whether the fees have been paid, the classification of the goods and services, and if there is a problem, the International Bureau may issue an irregularity, and once these are resolved, or if there are no irregularities, the international registration issues. At this point, the International Bureau, that's the part of WIPO that deals with the Madrid Protocol, sends out the request for protection to each of the designated jurisdictions in the international registration. So in this slide, that's shown under Request for Protection in the designated contracting party. So those are sent out to each of the jurisdictions where the marks undergo substantive examination and opposition. And after examination and or opposition, there may be refusal sent, or at the end of this, a statement of grant of protection confirming protection for some or all of the goods or services for which protection has been sought will be sent from the designated contracting parties back to the IB. In terms of where this information can be seen, the IB has an electronic database similar to CIPO's trademark database, where you can obtain details about the international registrations, their particulars, which countries have been designated, the classes of the goods and services, along with PDF copies of the documents sent from each of the designated contracting parties to the IB, including the refusals and grants of statements of protection. Along the left side of the slide, you'll notice that there is a note that there are very particular timing requirements, and that if refusal is not sent in within the timing requirements of the Madrid Protocol, the effect is that the mark is protected in that jurisdiction and a grant of protection should be issued. Countries adhering to the Madrid Protocol can elect for either a time limit of 12 or 18 months, and Canada will opt for the 18-month protection program, 18-month period of protection. So to provide an example, if a Canadian applicant has a Canadian application for Crunchy Creek cookies, covering cookies, cakes, frozen dough for baking desserts, and door-to-door selling of cookies, this could form the basis of an international application. The party could designate, for example, all of the goods and services in Mexico and the United States, and then only one or two of the goods and services in others, for example, Australia and New Zealand. The International Bureau would send the request for protection to each of these jurisdictions, where they would then be subject to examination and opposition. During examination, the office may notify the IB of a provisional refusal based on examination, and then if the mark is advertised, potentially a provisional refusal based on opposition, and eventually confirm either the refusal or send a statement of grant of protection, confirming that effectively the mark has the same protection as a registration in that jurisdiction. So today, our webinar is going to focus on those requests for protection that come into Canada and the impact of the Madrid Protocol on the opposition proceedings against applications, and for those registrations that come from those applications, protocol registrations, what will happen with Section 45 proceedings if there is a non-use Section 45 cancellation proceeding against a protocol registration. Before we get into the main topic of the webinar, I wanted to mention one other aspect of the Madrid Protocol that is not shown on this slide, but does have where the opposition board does have a slight role to play, and that's with respect to the period of dependency, where an international registration is dependent on its basic mark. So with respect to Articles 6.3 and 6.4 of the Madrid Protocol and Rule 22 of the Common Regulations, those are the regulations under the Madrid Protocol, the Office of Origin is required to notify the IB if there are certain changes in a basic application or registration, either within the first 5 years of the term of the international registration or after that 5-year period as a result of a proceeding commenced within that first 5-year period. In particular, CIPO would be required to notify the IB if during dependency the basic application was the subject of a rejection decision in respect of some of the goods and services listed within it. These goods and services would then be removed from the international registration. And I'll mention that there is a proposed regulation set out in Section 100 of the proposed Trademarks Regulations, where it sets out where the registrar will act as the office of origin. And to the extent that an opposition or Section 45 proceeding results in the refusal of a basic application, either in whole or in part, or the expungement of a basic registration, again, with just the deletion of some goods and services, or the expungement of the mark in its entirety, then IB will be notified. So these requests for protection that will come from the IB into Canada will be termed protocol applications. Every protocol application will be examined. If there is an office action, a provisional refusal will be notified to the IB within that 18-month period. The IB will record the provisional refusal in the International Register, and it will communicate the provisional refusal to the holder of the International Registration. With respect to CIPO, following our normal procedure with respect to national applications, the applicant will be notified of the office action, will be given the opportunity to respond, at which point the office will consider the response, and it will, as normally happens with prosecution, and eventually the confirmation of the refusal will go out, or the protocol application will be advertised. So protocol applications will be exposed in exactly the same manner as with respect to national marks, that is by the filing of the Statement of Opposition. So if a Statement of Opposition is received against a protocol application, within the critical timing requirements that we're going to spend a few minutes on shortly, CIPO will notify the provisional refusal based on opposition to the IB, and then dispose of the opposition as set out in the Trademarks Act and Regulations, and then at the end, notify the final decision to the IB, either by sending a confirmation of total provisional refusal or a statement of grant of protection. So going through this chart, on the left side is probably the simplest scenario where there is no opposition. So in that case, if a protocol application is advertised, there's no opposition, a registration certificate would issue, and a statement of grant of protection indicating that the mark was protected for all of the goods and services in the protocol application would be sent to the IB. If, when the mark is advertised, a statement of opposition is filed, a provisional refusal based on opposition would be sent from CIPO to the IB. The opposition proceeding would then go through the normal course. If the opposition was withdrawn or the opposition was rejected, either in whole for all of the goods and services or in parts for some of the goods and services, a registration certificate would issue, and a statement of grant of protection would be sent to the IB. The far right of the slide, where a provisional refusal is filed, and then if during the course of the opposition proceeding the application is withdrawn, or at the end of the opposition proceeding, an application is refused in its entirety, the refusal is for all the goods and services, a confirmation of total provisional refusal will be sent to the IB. Because of these timing requirements, provisional refusals must be communicated to the IB within 18 months, or for a provisional refusal based on opposition, if the IB has been previously notified that an opposition may occur after 18 months, there is another set period in which a provisional refusal can be sent. However, if there is no refusal sent within these time limits, the IB will extend protection automatically. Article 5.2c of the Madrid Protocol sets out the critical timing requirements. It sets out first that these provisional refusals must be sent within that 18-month period of time from when the IB notifies, in this case Canada, of the request for protection, or if prior to that 18-month time limit, if Canada advises the IB that it will be possible that oppositions will be filed after the 18 months, we will have this extended period, which is the earlier of 1 month from the expiry of the opposition period, but not later than 7 months from the date which the opposition period begins or the advertisement date. If these deadlines are not met, a statement of grant of protection will be issued and the mark will be registered, and this is captured in Section 132 of the regulations, where it indicates that if the 18 months has passed and no provisional refusal has been issued, or if there's an opposition but a provisional refusal based on opposition isn't notified within the time limits, the mark will be protected. So Section 129 of the proposed Trademark Regulations sets out the notification for the registrar to send if it appears likely that the opposition period will extend beyond the end of that 18 months. The plan is for this notification to be sent well in advance and automatically, and the goal is to have it sent in advance with sufficient time that any potential opponent would be able to request and receive at least 1 4-month extension of time to consider whether they were going to file a statement of opposition and prepare the statement of opposition. Section 125 of the proposed Trademarks Regulations place a limit on the length of extensions of time that can be granted, the maximum length, to ensure that CIPO will have sufficient time to prepare that provisional refusal based on a statement of opposition and forward it to the IB. The goal of this provision is to allow opponents to be able to request an extension of time and then provide us some time for administrative handling that will fall within the limits of the protocol. So it's a maximum extension of term on 4 months on request. The registrar will not have the discretion to extend an extension of time beyond 4 months on request, although the registrar preserves some discretion to extend the deadline, not on request, to cover situations where the registrar may need to rectify a situation. For example, if an extension of time request had been received but not previously granted. And so comparing this to that 7-month window where if notice is given to the IB, we'll have that 1 month from the 1 month of expiry of the opposition period, or 7 months from advertisement. That will allow the 2 months for the advertisement. If an extension is requested at the end of that 2 months, a further 4 months. The filing of the statement of opposition, allowing CIPO 1 month to notify the provisional refusal. Okay. So one of the policy goals throughout when the draft regulations and the preparation of the practice notice for oppositions to to protocol applications was, insofar as possible, to treat protocol applications the same as domestic applications. And so this is one of the provisions that, to the extent we can, mirrors the treatment. So Section 142 allows the registrar to withdraw a protocol registration from the registrar if that mark had been registered without considering a previously filed request for an extension of time, and if there is still sufficient time to notify the IB of an opposition. And this mirrors the Act with respect to the withdrawal of a registration in the same situation where there is a previously filed extension of time request that had not been acknowledged. So sections 126 and 127 set out first that in respect of protocol applications, the statement of opposition must be filed using the online service. And this is because the use of the online service will give parties instant confirmation, potentially prevent the mishandling of documents because we have that absolute deadline we'll always have to meet, and further, we'll make sure that the requirements of the IB with respect to provisional refusals are met. So in Rule 17 of the Common Regulations, the IB sets out what is required in a provisional refusal, and in particular, a provisional refusal based on opposition. And so some of the requirements match what's set out in our own Act and Regulations for things like the opponent's name and address, the grounds of opposition, but there are some requirements that are not mentioned in our Act and Regulations, and these include the particulars of relied upon trademarks and the grounds of opposition with reference to the applicable sections or provisions of the law. And so using the online service, the goal is to obtain all of the information and meet the requirements that the IB has for provisional refusals based on opposition. When a provisional refusal based on opposition is sent to the IB does review it. And if there is a problem with it and it does not meet the requirements, the IB will issue an irregularity. If it's an irregularity that is with respect to the time limit, in that the notification has been sent after those absolute deadlines, there's nothing that can be done. If, however, the irregularity is because other requirements are missing, CIPO will be given a 2-month period of time in which to remedy the irregularity. Because this 2-month period of time is very brief to, in some cases, follow up with the opponent to obtain the necessary information and then respond back to the IB, it was decided the preferable course of action was to insist on the use of an online system so that the chances of receiving an irregularity are greatly reduced or even eliminated. So we have a question that the online statement of opposition be saved and worked on over a period of time until it's ready to submit. I'm not sure, but I will send that on to IT, as that it's been mentioned that that ability to save is helpful. So here's a notification of a provisional refusal obtained from a WIPO webinar. And so you can see some of the requirements that were set out on the last slide and in Rule 17. You'll notice that the grounds of opposition are set out, as well as a note as to which sections that they pertain to, the opponent's name and address, and with reference to attachments, the particulars of the relied upon marks. You'll also see in Section 4 a note that the provisional refusal relates to all of the goods and services covered, and this will be similar to what Canada will send out, which is a provisional refusal against all of the goods and services for which protection has been requested, and this can be contrasted with some other jurisdictions where partial refusals are sent out. So when we send the notification of provisional refusal, it will be with respect to all of the goods and services in the for which protection has been sought or in the protocol application. So one of the other things that's been added in the regulations is a new ground of opposition setting out that the goods and services in the protocol application must be in the scope of the international registration. This would allow opponents to oppose a protocol application on the basis that goods and services are not within the scope of the international registration or go beyond the scope. In the current proposed trademarks regulations that were published in the Canadian Gazette, the link between the requirement about being within the scope of the protocol, the international registration, and the grounds of opposition set out in Section 38 of the Act was through the use of the wording not registrable. We have received comments after the publication in the Gazette on this particular linkage and are considering them. So once the statement of opposition is filed, a notification of provisional refusal will be sent to the IB. At the same time, that statement of opposition will be forwarded to the applicant, similar as is the case now, which triggers the deadline for the filing of the counter statement. So after the statement of opposition has been forwarded and the provisional refusal accepted by IB, the opposition will generally follow the usual process until a decision is reached and the appeal period has expired. So it will be subject to Section 38 of the Trademarks Act. Oppositions to protocol applications will follow the same procedures as set out in Sections 42 to 58 of the Trademarks Regulations, and as well as the procedures in the practice and trademarks opposition proceedings. There are a couple exceptions that we'll return to after reviewing what has happened after an opposition proceeding has concluded. So if during the course of an opposition, an application is deemed abandoned, then a confirmation of total provisional refusal will be sent to the IB. So there is the mechanism for Canada to alert the IB that the application has been abandoned is through confirmation of total provisional refusal. There isn't a separate notification for abandonment. If once a final decision issues, so that would be a decision that's not appealed, or if it has been appealed and judgment is decided in favor of the applicant refusing the application and there's no further appeal period or appeal is not taken, a confirmation of total provisional refusal will be sent to the IB. And this is when an application is refused with respect to all goods and services. So here's an example of a confirmation of total provisional refusal sent to the IB. You'll see it notes that the mark is refused for all of the goods and services. If during the course of the opposition is withdrawn, or there's a deemed withdrawal of the opposition, a statement of grant of protection will be sent to the IB. If, at the end of the opposition proceeding, a decision is reached, either rejecting the opposition in its entirety, and once that's a final decision, or if an appeal is taken, that the decision remains or that the opposition is rejected, the trademark will register, a registration certificate will issue, and a statement of grant of protection will be sent to the IB. If it's a split decision, so a decision issues that the opposition is rejected with respect to some of the goods and services, and the application is refused with respect to the remaining goods and services, similar as to what we see with applications now, the trademark is registered for the goods and services for which the opposition has been rejected, and a registration certificate issues. With respect to protocol applications, the same thing will happen. The registration certificate will issue for just those goods and services, and a statement of grant of protection will be sent to the IB, limited to those goods and services. And the language of this provision, in particular, section 132(1), it mirrors section 40 of the new Act, which also indicates when the registration certificate will issue. Thank you. So here is an example of a statement of grant of protection from the United States. And in this statement of grant of protection, you'll notice it says limited list. And so the list for which protection has been granted is limited to just those goods and services mentioned within. Okay. So similar to applications, protocol applications can be divided, and if divided in opposition, the opposition will continue against the original and divided applications. The provisional refusal based on opposition, which had been sent to the IB, will apply to both, because, as you may recall, when that provisional refusal has been sent out, it is sent out with respect to all of the goods and services. So then when the application, if an application is divided after, that provisional refusal will apply to both. So there are a few exceptions to this opposition proceeds as usual, where there can be impact during the course of the opposition of the Madrid Protocol. And the first is there's a prohibition against new grounds of opposition being raised. And then there are a few communications that could be received from the IB that would result in an amendment or withdrawal of the application and could impact the opposition in that way. So we'll go over the first exception. So section 128 of the proposed trademark regulations sets out that once the registrar has sent the IB a notification of provisional refusal based on opposition, the statement of opposition may not be amended to add a new ground of opposition. And this is consistent with those critical timing requirements, because Article 5.2 of the Madrid Protocol requires the grounds of opposition to be notified as of a certain deadline. And so this will ensure that only those grounds that were notified within that deadline form part of the statement of opposition. And it's also consistent with Rule 17 and 18 that set out the requirements of a provisional refusal and indicate that all required trademarks to be included along with their particulars at the filing. There's a guide to the Madrid Protocol, which also mentions that an office may not base a confirmation of total provisional refusal or a statement of grant of protection is granted on a ground which was not mentioned in a notification of provisional refusal made within the applicable time limit. We are preparing a draft practice notice where further detail will be provided, discussing what would be considered a new ground of opposition and contemplating that if an opponent relies on an application and that application later registers, that the addition of a Section 12(1)D ground based on that would not be a new ground of opposition because the particulars of that mark have already been provided to the IB. So there are a number of communications that could be received by CIPO from the IB that could have an impact on opposition proceedings. So with respect to the first one, a limitation is a limitation that's filed by a holder of an international registration. It's filed with the IB, and it limits the list of goods and services with respect to some or all of the designated contracting parties. And so that could be that the holder wishes to delete a particular good or service or a class from their application, or instead of deleting a good and service, they're describing it more specifically or narrowing it. If that happens at the IB, CIPO will receive a notification of that limitation, and that could impact an opposition proceeding because it could result in the amendment of the protocol application. For example, if the holder of the applicant had decided to delete Class 5 through the filing of a limitation, that class would no longer be in the protocol application, or it could even result in withdrawal of the protocol application in its entirety. So this would be the case if there was an international registration covering Classes 3, 5, and 7. A request for protection had been filed in Canada. There was a protocol application advertised, and during the course of examination, there was only Class 3 remaining. So the protocol application with only Class 3 was advertised. If the holder of the international registration deletes Class 3, there would be nothing remaining in Canada. The protocol application would be withdrawn. There's obviously no opposition proceeding. So that's with respect to limitations. When we were giving this webinar yesterday, there was a question at this point asking if parties had to file limitations or if during the course of an opposition could a party amend an application directly with CIPO? And the answer to that is yes. If during the course of an opposition, a party wishes to amend their protocol application, they'll still be able to file a revised application with CIPO with the amendment, and we would process it as in the normal course. And if, for example, it's an amendment that results in settlement of the opposition, the protocol application would be amended. In that case, at that time, the opposition opponent withdrew their opposition. The opposition proceeding would close, and a statement of grant of protection would be issued. So really, that limitation is a separate track that would allow holders to make those changes at the level of their international registration, but you'd still be able to amend a protocol application during the course of opposition with the office. So the next one is renunciation, and renunciation is renunciation of the IR with respect to some, but not all of the designated contracting parties for all of the goods and services. And if CIPO receives notification of this, the protocol application will be withdrawn. If there's a cancellation of an IR with respect, it could be with respect to all of the goods and services or just some of the goods and services, similar to limitations, that could result in the amendment to the protocol application or the withdrawal of it in its entirety. If there's a non-renewal of the international registration, so if the international registration fails to renew with respect to Canada, the protocol application would be withdrawn. And the last type of communication from the IB, which has the potential to impact opposition, is if the IB alerts us to a correction, and depending on the nature of the correction, it may be, if it's something, a very substantive correction, for example, we were only notified the request of protection with respect to Class 3, and it was advertised and opposed, and then later a correction is received that it also included Class 5, that would return back to examination. There are other corrections that we could receive during the course of opposition which would not have that dramatic effect. For example, corrections to the opponent's address or perhaps to some of the spellings of the goods and services. So we've also had a question come in, and I'm just, I'll read it out loud in a minute. So the question relates to, is there an impact if you actively withdraw an opposition after an amendment to settle versus doing nothing and one of the parties misses a deadline? Will there be a requirement to actively withdraw the opposition? So within the regulations and act, there are certain steps where if the deadline is not met, an opposition is considered withdrawn, and there's nothing about the Madrid Protocol that changes that. If those deadlines are not met, similar to the case with a regular application, the opposition will be deemed withdrawn and the protocol application will register. An opponent can always let us know, as is the case with regular applications, with respect to protocol applications, if they are withdrawing the opposition, at which point the opposition will be withdrawn and the trademark will register and a statement of grant of protection will be filed. Will be sent to the IB. So there's only one slide on Section 45 proceedings because the impact of the Madrid Protocol on Section 45 proceedings, non-use cancellation proceedings against protocol registrations, is relatively limited, and it occurs at the end of the proceeding after all the steps have been taken. So at the outset, I'll confirm that because there's this very limited impact, a protocol registration will be treated the same as a domestic registration with respect to Section 45 non-use cancellation proceedings. And what this will look like is now going on the far left of the slide. If there's a Section 45 notice issued and no evidence is filed with respect to that protocol use of that protocol registration, the registration will be expunged and the IB will be notified of the invalidation of the protection in Canada. This will be done as an invalidation under Rule 19 of the Common Regulations, and it will be done once the decision is final, so that either the appeal period has passed, or if there is an appeal, there's been a final judgment issued and no further appeal periods for that. If with respect, now moving to the right side of the chart, the Section 45 notice is issued and evidence is filed and the registration is maintained, nothing will go to the IB. So there's no requirement to notify them of an ongoing proceeding against a protocol registration, and if it's maintained in its entirety, there is no communication. Now going to the middle, if the registration is expunged, after evidence is filed and considered, they'll be alerted to the invalidation of the full registration, request for protection in Canada. If some goods or services are expunged, the IB will be notified of the invalidation of the registration, but just with respect to those goods and services will be a partial invalidation. So that's the last slide of our webinar today. We did leave time for questions, so if anyone has any questions, we do have the time. So we're not receiving any questions, so that will conclude the webinar. I thank you very much for your time today and for attending. And the recording of the webinar, and to the extent that there are questions posed in the other sessions, this will be sent out either on the listserv or some other notification to let you know when it's online, and you'll see the answers to the other questions there and can view the slides again. Thank you very much.